International Humanitarian Law. The Introductions to International Humanitarian Law, the IHL. The Fundamental Principles of IHL. Sources of IHL. Scope of applications of IHL. Protected persons under IHL. Key provisions. Breaches of IHL. Enforcement of IHL. Development and disseminations of IHL, challenges and future developments, as well as the summary and conclusions. International Humanitarian Law, IHL, is a body of rules established by treaties and customs. It is designed to restrict the methods and means of warfare employed by belligerents against each other. This area of IHL relates to the law of armed conflicts and was mainly developed by the Hague Conventions, the Hague Law. It protects persons who are not or no longer participating in hostilities, such as civilians, prisoners of war, and the sick and wounded. This area of IHL concerns the protection of victims of armed conflicts and was primarily regulated by the four 1949 Geneva Conventions, the Geneva Law. The Hague Law and the Geneva Law were merged with the adoption of Protocols 1 and 2 to the Geneva Conventions in 1977. The International Humanitarian Law. International law makes a crucial distinctions between two sets of rules, those concerning the resort to war, jus ad bellum, and those governing the conduct of war, jus in bello. International humanitarian law is primarily concerned with the latter, which is the jus in bello. IHL is a comprehensive body of rules established through both treaty and customs. Its primary objectives are twofold. The first is to limit the methods and means of warfare employed by belligerents against each other. This aspect of IHL relates to the law of armed conflicts and was predominantly developed through the Hague Conventions, commonly referred to as the Hague Law. And the second one is to protect persons who are not or are no longer participating in hostilities. This includes civilians, prisoners of war, and those who are sick or wounded. This area of IHL focuses on the protection of victims of armed conflicts and was primarily regulated by the four 1949 Geneva Conventions known as the Geneva Law. A significant development in IHL occurred with the adoptions of the 1977 additional protocols 1 and 2 to the Geneva Conventions, which effectively merged the Hague Law and the Geneva Law. It is worth noting that there is an ongoing debate within the international legal community regarding the need to update IHL to address the challenges of the 21st century. These challenges include the increasing frequency of internal conflicts, the development of modern weaponry, the growing relationship between international humanitarian law and human rights law, the fundamental principles of IHL. IHL recognizes 6 principles as being of a fundamental nature. These principles form the cornerstone of IHL and guide its applications in various contexts. The first is the principle of humanity, the principle of military necessity, the principle of proportionality, the principle of distinction between civilians and combatants, the principle of prohibitions of use of weapons of a nature to cause superfluous injury or unnecessary suffering, and finally, the principle of independence of jus in bello from jus ad bellum. The principle of humanity, this is the bedrock of IHL. It stipulates that all persons affected by armed conflict must be treated humanly in all circumstances. This principle prohibits the infliction of all forms of violence to life and persons. particularly murder, mutilations, cruel treatment, and torture. It also forbids outrages upon personal dignity, including humiliating and degrading treatment. The principle of necessity. It allows measures which are actually necessary to accomplish a legitimate military purpose and are not otherwise prohibited by IHL. However, it's crucial to note that military necessity cannot justify actions that are prohibited by law, as the laws of war have already taken this principle into account. The principle of proportionality. This principle requires that the losses resulting from military action should not be excessive in relation to the expected military advantage. It aims to minimize incidental loss of civilian life, injury to civilians, and damage to civilian objects. The principle of distinctions, which is between civilians and combatants. This principle is fundamental to IHL. It requires parties to a conflict to distinguish at all times between the civilian populations and combatants, and between civilian objects and military objectives. Attacks may only be directed against combatants and military objectives. Principle of prohibitions of use of weapons of a nature to cause superfluous injury or unnecessary suffering. This principle forbids the use of weapons and methods of warfare that are of a nature to cause superfluous injury or unnecessary suffering. It aims to minimize suffering and injury beyond what is necessary to achieve legitimate military objectives. Principle of independence between jus in bello and jus ad bellum. This principle establishes that IHL applies to all parties in an armed conflict, regardless of the reasons for the conflict or the justness of the causes for which they are fighting. It ensures that all victims of armed conflict are equally protected, irrespective of which side they are on. There are key treaties and conventions in the international humanitarian law. It includes conventions on biological and chemical weapons, conventional weapons and mines, child involvement in armed conflict, the Hague Conventions, the Geneva Conventions, and other relevant treaties. The most important of these conventions are the Geneva Conventions of 1949. The first Geneva Conventions concerning the ameliorations of the conditions of the wounded and sick in armed forces in the field. The second Geneva Conventions for the ameliorations of the conditions of wounded, sick, and shipwrecked members of armed forces at sea. The third Geneva Conventions relative to the treatment of prisoners of war, and the fourth Geneva Conventions relative to the protection of civilian persons in time of war. And there are also additional protocols of 1977 to the Geneva Conventions. Protocol 1 relating to the protection of victims of international armed conflicts, and Protocol 2 relating to the protection of victims of non-international armed conflicts. Customary international law, it consists of rules that come from a general practice accepted as law and exists independent of treaty law. Many of the rules and principles of IHL are now considered part of customary international law. This is particularly important as it binds all states, regardless of whether they have ratified specific treaties. The scope of applications of the IHL, it applies in two main types of situations. The first is international armed conflict. These are conflicts between two or more states. The full body of IHL applies to such conflicts, including the four Geneva Conventions and additional protocol number 1. Whereas the non-international armed conflicts are conflicts between governmental forces and non-governmental armed groups, or between such groups only. A more limited set of rules apply to these conflicts, primarily Common Article 3 to the Geneva Conventions and Additional Protocol number 2. It is important to note that IHL does not apply to situations of internal internal disturbances and tensions, such as riots, isolated and sporadic acts of violence, and other acts of a similar nature. Protected persons under IHL, because IHL provides protection for various categories of persons during armed conflicts. The first one is civilians. Civilians are protected against direct attacks unless and for such time as they take a direct part in hostilities. The Fourth Geneva Conventions and Additional Protocol 1 provide detailed rules for their protection. The prisoners of war, the POWs, are combatants who have fallen into the power of the enemy. They are protected under the Third Geneva Conventions, which provides detailed rules for their treatment. The wounded, sick, and shipwrecked. These persons are protected under the First and Second Geneva Conventions, as well as Additional Protocol 1. They must be respected, protected, and cared for by the party to the conflict in whose power they are. Medical and religious personnel. Medical personnel exclusively assigned to medical duties, as well as religious personnel, are protected under IHL. They must be respected and protected in all circumstances. Common Article 3 to the Geneva Conventions applies to non-international armed conflicts and sets forth minimum standards of treatment that must be afforded to all persons taking no active part in hostilities. It prohibits violence to life and persons, in particular murder, mutilations, cruel treatment, and torture, taking of hostages, outrages upon personal dignity, the passing sentences and carrying out of executions without previous judgment by a regularly constituted court. Additional Protocol 1 of 1977, it supplements the Geneva Conventions for International Armed Conflicts. The key provisions of this protocol include the expansions of the definitions of international armed conflicts to include wars of national liberations, strengthening of the protection of civilians, including the principle of distinctions, regulations of the methods and means of warfare, specific protections for women and children, provisions on the protections of the natural environment. Additional Protocol 2, 1977, it applies to non-international armed conflicts. It develops and supplements Common Article 3, providing more detailed rules for the protection of victims in non-international armed conflicts. The key provisions include prohibition of attacks on civilians, protection of objects indispensable to the survival of the civilian populations, protection of cultural objects and places of worship, prohibitions of forced movements of civilians, and safeguards for persons deprived of their liberty. The breaches of IHL distinguishes between two types of breaches. The first one is grave breaches. Grave breaches are defined in the Geneva Conventions and Additional Protocol 1. They constitute criminal offenses punishable through penal proceedings. Examples include willful killing, torture or inhuman treatment, willfully causing great suffering or serious injury to body or health, extensive destructions and appropriations of property not justified by military necessity and carried out unlawfully and unwantonly, compelling a prisoner of war or a protected civilian to serve in the forces of hostile power, willfully depriving a prisoner of war or a protected person of the rights of fair and regular trial, unlawful deportations or transfer of a protected civilian, as well as taking of hostages. The other breaches, which are not considered as grave, are punished through disciplinary procedures. The enforcement of IHL at national and international level. At national level, IHL imposes and obligations on each contracting party to implement and enforce its provisions. This includes enacting national legislations to implement law, the IHL, disseminating knowledge of IHL, training armed forces in IHL, and prosecuting alleged war criminals under the principle of universal jurisdiction. The role of the International Committee of the Red Cross, ICRC. The International Committee of the Red Cross, established in 1863, plays a crucial role in the development and implementations of IHL. The ICRC initiates and develops IHL, proposing new treaties or revisions to existing ones. The ICRC works to spread knowledge of IHL among armed forces and civil society. The ICRC monitors compliance with IHL and reminds parties to conflicts of their obligations. The ICRC provides protections and assistance to victims of armed conflicts and other situations of violence. The ICRC runs the Central Tracing Agency, which works to reunite families separated by conflict. The ICRC is recognized as the guardian of the Geneva Conventions with a special role in ensuring their respect. Challenges and future developments in IHL. As warfare evolves, IHL faces new challenges. Asymmetric warfare and non-state armed groups, the increasing prevalence of conflicts. Asymmetric warfare involving non-state armed groups poses challenges to the traditional state-centric model of IHL. New technologies, such as the development of new weapons technologies, autonomous weapon systems, and cyber warfare capabilities, raises questions about the applications of existing IHL rules. Climate change and armed conflict. The potential impact of climate change on armed conflicts and the applications of IHL in climate-related disasters is an emerging area of concern. The relationship between international humanitarian law and human rights law is evolving, especially in situations of occupations and non-international armed conflicts. This interplay is continued to develop over time. Urban warfare, the increasing occurrence of armed conflicts in densely populated urban areas presents challenges for the principle of distinctions and protection of civilians, strengthening compliance mechanisms. There is ongoing discussions about how to improve compliance with IHL, including proposals for new mechanisms or strengthening existing ones. International humanitarian law represents a crucial framework for regulating the conduct of armed conflicts and protecting those who are not, or are no longer participating in hostilities. From its early roots and customary practices to the comprehensive treaty regime we have today, IHL has evolved significantly. However, it continues to face challenges in the context of modern warfare and changing global dynamics.